Okay, let's begin by assuming that the state is considering imposing a requirement on local government, something that would require new governmental activities. Would it be a reimbursable mandate? The first thing you should do in considering this question is assess whether the requirement fits any of the exemptions in the Constitution, statutes, or case law. If the requirement meets any of these exemptions, the Constitution does not require the state to reimburse local governments. Of course, the state could choose to reimburse local governments for their cost, but the Constitution doesn't require it. What are the exemptions? Well, there are certain exemptions that are explicitly mentioned in the Constitution. Let's talk about these constitutional exemptions first. The Constitution says that the legislature need not provide reimbursement in 3 cases. The first is state requirements imposed before January 1, 1975. This is the start date for reimbursable mandates. The state need not reimburse requirements that existed before this date. The Constitution also exempts state laws defining crimes or changing the definition of a crime. Changing the penalty, say, for drug possession, might require a county to keep someone in jail longer, but the Constitution tells us that the state is not required to reimburse these costs. The last exemption specified in the Constitution is state requirements that local agencies requested. For example, if a city asked the legislature to pass a law requiring it to have a police officer at every street corner, that city's cost to follow the law would not be a reimbursable mandate. In addition to these 3 exemptions mentioned in the Constitution, there are 4 broad categories of state requirements that, under current court rulings and legal thinking, appear to be exempt from the Constitution's reimbursement requirement. Voter-approved initiatives, federal requirements, anything local agencies have a choice whether to implement, requirements that a local agency could pay for with other money, and requirements on certain local agencies. This list is very complex, so let's take these categories one by one. First, requirements specified in a voter-approved initiative or federal law are not considered reimbursable mandates. Why is this? Remember that the language of the Constitution says whenever the legislature or any state agency mandates. Well, in the case of voter-approved initiatives or federal requirements, the voters or federal government impose the requirement, not the state. So these requirements don't fit the language of the Constitution. What about state laws that implement a voter-approved initiative or federal law? That is, the requirement isn't directly spelled out in the voter-approved measure or the federal mandate, but is incorporated in state legislation enacted to implement a voter-approved measure or federal requirement. Recent legislation directs the Commission on State Mandates, and that's the commission that hears mandate claims, not to find a reimbursable mandate under these circumstances. The thinking is that if the legislature is simply giving life to a voter-approved or federal requirement, then the state isn't freely choosing to impose a mandate. State actions that go far beyond what is needed to implement a voter-approved or federal mandate, however, are not covered by this exemption. The second group of state requirements that are not considered reimbursable mandates under current legal thinking is anything that a local agency has a choice whether to implement. Why is this? Well, if legislation says a local agency may do something, then it's permissive, not a reimbursable mandate. This is true even if the state says, if you do X, the state will provide new money or something else desirable. In addition, if state law imposes a mandatory requirement on an optional program, the requirement usually isn't considered a reimbursable mandate. What's an example of this? Well, many schools have chosen to create advisory boards called site councils. having a site council make schools eligible for some extra state or federal money. When the legislature imposed Open Meeting Act requirements on site councils, the court said that the cost to comply with these Open Meeting Act requirements were costs associated with an optional program and thus not a reimbursable mandate. The third category of state requirements, generally thought not to constitute a reimbursable mandate, are requirements that a local agency could pay for with fee revenues, additional revenues provided by the state, or through offsetting savings. The thinking here is that if a requirement doesn't place financial pressure on the local agency's tax revenues, then there's no responsibility to reimburse. The most commonly cited part of this exemption is fees. It's important to note that the local government preferences regarding fees is not a factor. If a local agency could offset the cost of a requirement with fees, the courts have ruled that it is not a reimbursable mandate. As an example, consider a state requirement that local recreation departments give health information to people enrolled in fee-financed exercise classes. The Park and Recreation Department could comply with this requirement by increasing the fee for the class. In this case, then, the requirement would not be a reimbursable mandate. What about the part of this exemption relating to state funding or offsetting savings? Frankly, these provisions are cited very infrequently, and the legal thinking isn't entirely clear. In general, a state requirement would be exempt from the reimbursement requirement if the state created a mandatory requirement and clearly designated some state funding that the local agency could use to pay for the requirement. In terms of the offsetting savings provision, any savings should be realizable in the near term and benefit the agency that paid the cost of the mandatory requirement. The final category of state requirements that are not considered to be reimbursable mandates are state requirements on local agencies other than a city, county, special district, school, or community college district. This fourth category is controversial and the topic of litigation. The current thinking is that requirements on joint powers agencies, redevelopment agencies, councils of government, and charter schools are not state reimbursable mandates. Why is this? Well, other local agencies voluntarily created these agencies and chose to implement their programs. In addition, these agencies did not levy a property tax before Proposition 13, and thus it is reasoned the fiscal protection created by Proposition 4 was not intended for them. And finally, state law doesn't define these agencies as eligible claimants in the mandate reimbursement process. So to recap, a reimbursable mandate is a requirement freely imposed by the state on local agencies, and it's one that requires local agencies to pay for a new program or a higher level of service. A requirement is not a reimbursable mandate, however, if it was imposed before 1975, or to carry out federal law or a voter-approved initiative, or at the request of a local agency. A requirement also is not a state reimbursable mandate if it defines a crime, is voluntary or imposed in a program that the local government's elected to create, or is possible to finance through fees, designated state revenues, or offsetting savings, or if it was imposed on a type of local agency that never levied a property tax, such as a redevelopment agency or a charter school. While the list of mandate exemptions is long, it's important to note that the Commission on State Mandates has found many state laws, executive orders, and state agency regulations to be reimbursable mandates. In addition, the state pays local agencies hundreds of millions of dollars annually for mandates, and every year local agencies file more claims with the Commission on State Mandates, alleging that a new state requirement imposes a reimbursable mandate.